Walmart also trading higher today because of a win in the Supreme Court. The Supreme Court today essentially blocked a massive sex discrimination suit against Walmart that could have involved up to 1.6 million women. They didn't rule on the merits of the case, but merely stripped it of its class action status, essentially meaning now that the individual plaintiffs will have to take up the case on their own individually, perhaps making it more difficult down the road for other employees of other companies to mount large-scale bias claims against some of the nation's biggest companies. But we want to look at the possible ripple effect of this case. Let's bring in Andrew Stoltmann. He's a partner at the Stoltmann Law Offices, and Charles Smith is partner at Skadden Arps, Slate, Meagher, and Flom. Gentlemen, thank you both for joining us today. Andrew, you call this the worst Supreme Court decision of the last 15 years. Why?
It's bad because it effectively closes the door on many meritorious victims who might be able to move forward with this, with claims against Walmart. It has, in effect, closed the door on these people, and that's really problematic.
Chuck, you agree with the decision, or at least you say it makes sense. Why?
It's not an outlier of a decision. It's right in the mainstream of where class action cases would expect to come down. And what this case does is basically say, plaintiffs, you can't just assert that you've got common issues of fact that allow you to combine up 1.6 million people into a single case. You have to actually have some proof of that. And what the court found was that the plaintiffs in this case didn't meet their burden of proving that they had common issues so that all 1.6 million plaintiffs' cases could be tried together in one class action.
Andrew?
But look, there was statistical evidence through a regression analysis that, in fact, there was discrimination. It was established, for example, that 70% of the hourly jobs were of women, but only 30% of the managerial jobs were. I mean, I'm not saying it was a perfect case, but there was certainly enough information and enough allegations to get over that hump. And all I'm saying is give these women a chance to present their case. And the Supreme Court didn't do that.
You guys are the experts on this. I'm not. But can you have only half of the 1.6 million qualify and keep them in there? Or isn't it an either-or situation here?
Look, I think it's a situation where you let the class action go forward. All of this stuff can be established in discovery. If there's some people who shouldn't be in it, those people can eventually be moved out. But at least let them get through that first step, which is the certification of the class action.
Chuck, should we be suspicious at all that this, essentially the vote came down by political ideology on the court?
Actually, it didn't. The vote was 9-0 on aspects of the case, including that no class should have been certified here, that there was a mistake in certifying the class. It was a 5-4 decision on how you get there, but the outcome was the same. This is not a politically driven decision. It's a decision that's driven about what works as a judicial proceeding. And having more than 1.5 million women in a situation where part of the plaintiff's argument was managers had too much discretion in individual circumstances, then what you were going to end up with was a totally unwieldy case. And the other thing I'd add is it's completely unrealistic to say, just let the case proceed. If you let a case of 1.5 billion plaintiffs proceed against a company like Walmart, it's going to exert tremendous pressure on Walmart to settle the case.
I know it's Walmart, but it was 1.5 million. But anyway.
Yes.
Andrew, does this raise the bar too high for future possible class action suits in your view?
It does. It makes certainly employment actions, and I have a feeling class actions based on race almost impossible because that commonality standard becomes so high, it becomes almost impossible to meet it. And that's what I think is really unfortunate with this decision.
Chuck, what do you think?
Now, there are a number of employment cases, for example, that involve common practices by a company, so that where they're using tests for employment issues and there are biases in the tests, or where they are using a common policy that has the effect of either racially or discriminating on gender. And in those cases could be proceeding on a class basis. But what can't happen is a statistical study of individualized determinations leading to a class action. I think this really does foreclose.
Very quickly, I have a question, and I haven't seen this anywhere today. Is Walmart out of the woods? I mean, these women can still bring their cases, but they have to do it individually now. I mean, this is going to be that much more cumbersome, I would think, for Walmart in the future, Andrew.
Yeah, you know, it's going to be, but in the same sense, I expect 98% of those people not to come forward simply because of the costs and the hurdles associated with an individual lawsuit like that. So it is, of course, a major victory for Walmart. I expect very few of these people to come forward on an individual basis.
Andrew Stoltmann, Chuck Smith, good to see you both. Thank you for your insights today. Appreciate it very much.
Thank you.
Thank you, Bill.